Okay, so we're recording this segment. Is there any objections to recording? We're all okay to record? Good, good. So the relevance of legislation. The relevance of legislation referred to in relation to counselling practice. So we've talked about key legislations. Now we're going to reflect on the policies a counselling service needs to have in place in relation to legislation, how these policies will be used to ensure best practice. So the data protection, we sort of touched on note taking because you're going to be taking notes. So making and keeping notes of clients is important for practical therapeutic sessions, and in view of that, then that's relevant to you as a counsellor. Counselling records are classed as sensitive personal data. For the purpose of the Act, must be stored or must meet the most stringent obligations for confidentiality and safe storage. Clear policies must be in place in respect of these records as outlined below. For record keeping, clients must consent records being kept and made. For example, the BACP requires counsellors to keep accurate records that are adequate, relevant, and limited to what is necessary for the type of service being provided and comply with data protection requirements. That can be seen on page 14 of the framework. Writing reports. Written reports may be required, for example, by a healthcare professional for legal proceedings. Clients should be made aware of any request for the counsellor to produce a written report and their consent obtained, unless there is a legal reason which justifies disclosure without consent. If it is an ongoing requirement as part of their therapy, then this should be explicit in the contract. Storing client notes. Client notes must be kept securely in a locked file cabinet or electronically secure files on the computer. It must be stored in a way which ensures anonymity so the client cannot be identified from the records. Keeping client information. Records are often destroyed after counselling has ended, session has ended. Subject to other legal or professional requirements, a client should be notified in the contract of how long their records will be kept and should be kept for no longer than necessary. So you tell the client at the beginning, how long we keep your records, while we're keeping them for, and we won't keep anything longer than we need to keep them. Data protection confidentiality, they must clearly explain the circumstances. So you must clearly explain when it's broken and information is disclosed. This is appropriate to data protection. Autonomy, practitioners must respect the client's right to know about and exercise control over their personal information, the purpose for which is being kept and how long it is being kept. Agency policy. Counsellors may work in settings where they must take entries on agency records which are available to certain personnel within the agency or even passed on to another agency. The counsellor should negotiate an agreement with both agency and the client and establish clear guidelines. Okay. So that was the data protection. Now we'll look at how the Children's Act 2004 applies to counsellors. Well, counsellors need to identify and respond when children might be at risk or harm, that we talked about earlier, and must report any child protection concerns. If a counsellor works for an agency, so you work for an agency, they must ensure they understand the agency's policies relating to child protection and safeguarding. In private practice, counsellors need to develop robust policies for what they do if they have safeguarding concerns about a child. Anyone working with children must undertake a DBS. We're all familiar with DBS. Counsellors need to be aware that when an adult client discusses causing harm to them or another adult, that person may pose a threat to a child. client may tell you about circumstances which could affect the safety of their own children or children they know, people in the care of children, or in the wider community. Okay. The Equality Act. This framework requires that counsellors take the law concerning equality, diversity, inclusion into careful consideration and strive for a higher standard than a legal minimum. That can be seen on paragraph 23, page 15 of the BACP framework. A counsellor cannot refuse to provide counselling service to someone because of the characteristics protected by the Equality Act. Okay. Counsellors must be an accessible service where diversity is recognised to ensure clients are treated as unique individuals. When a client has a different personal characteristics culture from the counsellor may need to adapt their approach to fully meet the needs of the client and ensure they receive fair and non-discriminatory treatment. This could include getting guidance from an organisation with specialist knowledge. Practitioners may also need to be aware of their own prejudices and bias so that their impact is minimised. According to Mill 210, person-centered core conditions of congruence, empathy, and unconditional positive regard are the cornerstone of cross-cultural work alongside challenging of white-dominated Western cultural ideas and willingness to embrace the client's culture and way of being. Okay, so now we'll look at the Mental Health Act. The Mental Health Act 1983. In terms of mental capacity, the client can make and maintain psychological contact, then therapy may be suitable with appropriate safeguards. For example, a legal guardian could deal with the formalities of the contract. The framework is also relevant here in terms of core principles of beneficence and non-maleficence and our commitment to work with competence. We should be cautious and take advice in supervision or from a relevant experienced professional when working with clients whose condition or behaviours may challenge the therapist beyond their remit of competence. That's BACP 219, page 49. Just what we sort of talked a lot about this course, about staying within your remit. A counsellor should also consider consulting with or making a referral to the client's GP or other healthcare professional. Referrals are usually made with the client's consent, and this will depend on circumstances. Referrals should be discussed in supervision. We also have a duty of care and need to be aware of any risks posed to ourselves. Agency policy may also assess client as part of initial screening before counselling begins, so as to identify any potential mental health needs. So this examples include the PHQ9 form, for example. So I can sort of show you that can sort of be useful as a screening process to identify any specific needs the person might have or they might need to refer or the purpose of what you're doing. So finally, the safe environment for counselling. Settings should always be comfortable, non-confrontational. There should be no barriers, ideally, between the client and counsellor, such as desk or clutter. The counsellor should always be in a position, could argue, near the exit, for a variety of reasons. One being maybe if the client becomes aggressive, or perhaps it could be down to the Health and Safety Act to guide someone in case of a fire. So it would make sense for you to be close to the exit for that. The risk assessment should be undertaken. So wherever you practice, you do a risk assessment based on 1974, the Health and Safety Act. Fire safety equipment procedures you've got in place. And it might be worth sort of telling the person in the contracting what you do if there's a fire or anything else. And important to ensure the environment in which the sessions take place is suitable and safe for the client and counsellor. The use of soft lighting, for example, you know, room temperature, just a comfortable environment to be in, you know, for the patients. Counselling. Other key points of consideration in the environment is the contract detailing behaviours expected of the client and therapist. It's also useful, very important to sort of know what they're looking for in counselling in the beginning. Can I fulfil that? Is that within my remit? Room temperature, distractions avoided, phones off, ideally, soundproof as well, to ensure confidentiality, timekeeping, ideally, and location of fire access, toilets, any sort of disability arrangements that they might have coming along. So we'll sort of take some questions now. Just stop presenting. I'll stop the, okay. That seems to be transcripted. Oh, it's got you got a transcript there as well. Wow.